Hello, this is Dave Siegel. Welcome to Legal Action. It's summertime, school is out, for sale signs are up. That's right, we're talking real estate. It's that time again to buy and sell real estate, and the market is ripe once again. Joining me today is Jesse Barrientes.
Good evening. How you doing,
You
Dave?
are an attorney in the area, Chicagoland area, is that correct?
Yes, we do Cook, Kane, DuPage, several counties.
And you know quite a bit about real estate, that's why you're here.
Well, we've done a lot of real estate. It's been a staple in our practice, a part of the general practice, you bet.
Well, so much is going on right now in real estate this time of the year. Everywhere you look around, there's for sale signs, by owner, realtor, internet. Is this the time?
That's correct. Yeah, generally the spring and summertime are the time where a lot of the sales kind of open up. You also have a good time because now the children aren't in school, and so you don't have to worry about displacing them, and it's something that you can get done within a couple of months, really.
But there's also a window before the children go back to school, and a lot of people want to buy and sell the property during that time. So doesn't that put on a little additional pressure to either find the right home or to find the right buyer for your home?
Yeah, if you can do it within that in the summertime, it's really a great time. The truth is that people buy and sell houses all year round, really, but really where you see the concentration is in the summer months.
Okay. One of the things I think is important, and I think you would agree, if you're looking for real estate or looking to sell real estate, is that you have a team in place, such as a real estate attorney, so that the minute you enter into a contract, you can immediately pass that contract over to your counsel to get representation started immediately. What's the advantage of that?
That's exactly right. You have, and we'll talk about those in a moment, but some time periods that are generally 5 business days, and you want to be able to make sure that your attorney has the documents after it's been accepted. You want them to have it right away. And you're talking about a team, and that's important. It's not just the attorney. It's also your banker or broker, the loan officer that's going to be involved in the transaction as well. It's a good idea oftentimes to get a pre-approval letter from your bank or from your lender, because that makes, when you go and make an offer, that makes the seller, that makes you a little more attractive to the seller because you've been pre-approved for a certain amount. Sure.
Let's talk about the buying and the selling. I mean, this is a real estate deal, so we need a contract to effectuate this transfer. Is that correct?
That's exactly right. And they have many contracts out there from the real estate board. One of the recent ones around here in the western suburbs are the 3.0. I believe they've upgraded now to the 4.0. And it's a multi-page contract that covers just about every aspect of the transaction.
Yeah. Let's run through a few of those bullet points. Obviously, the address of the property is the most important thing.
Address, legal description, it gives a kind of lot size really, but a lot of times that's, you'll get a survey, which is, we'll talk about a little bit later too, included in that. And then you want to talk about things, for example, what's going to go along with that real estate.
You're talking about fixtures and personal property?
That's right, the personal property.
Would this include utilities, draperies, anything that's affixed to the interior of the property or the exterior? Right,
or that's not attached, like your washer and dryer and your refrigerator. Sometimes there are other things that may go with it. Maybe on the outside shed or whatever. I mean, just all those kinds of things. And you want to really make sure, television antenna. You want to really make sure if you're selling and you're not intending on selling the washer and dryer along with the property, that's not marked. The real estate agent hasn't kind of marked that off. And if you're going to exclude something, for example, the antenna, if that's something that's going to come with you, you want to make sure that there's a line generally for items that are specifically excluded.
Okay. Item number 4 of the residential real estate contract that you mentioned before is the purchase price.
Purchase price.
Is there anything more critical than the purchase price?
The purchase price is very important for a lot of reasons, obviously.
Okay. What's the reason why it is absolutely the most important item?
Well, the purchase price is not something you're going to be able to modify later, according to the attorney's approval provision. But you want to make sure that it's an amount that's within your budget. It's an amount that you're going to be able to get a loan for. It's actually okay because if you can't get the financing, and we'll talk a little bit about that,
right,
in a bit, then you're not going to be able to get a mortgage commitment, and that would be a way to back out of the deal.
Right. So other items in the contract can be negotiated, talked about, reduced, enlarged, but the one thing that stays solid is the purchase price if the deal is going to complete, correct?
That's absolutely correct. And that really brings us to the reason for that. One of the, or a couple of the major deadlines that come up pretty quickly are the attorney's approval and the inspection provisions of the contract. The attorney's approval allows you to modify anything, any terms in the contract, except for the purchase price. And generally, in most contracts, and again, it's important that you look at it, important to have your team in place so your attorney knows and calendars those dates. Generally, it's 5 business days from the date of acceptance. The date of acceptance is when the sellers have actually kind of signed off on the contract. So as a purchaser, you would go with your realtor, if it's a realtor is involved, and you talk to him and decide what your kind of offer you're going to make, and he would write up the contract, and then it would be presented to the seller. And very often, the price is negotiated, so maybe the seller wants a little more, and the seller kind of crosses out the price and puts a little higher price and initials that, and then it goes back.
What if a buyer comes to you with a contract and the attorney approval period has already run? In other words, they've sat on the contract and then realized, oh, we do need an attorney to help us with this deal, and let's say it's 15 or 20 days down the road. What happens then?
Well, technically, according to the contract, if it's like the 3.0, if it's 5 business days, then really you've waived that provision. And the inspection provision is generally 5 business days as well. If you waive that provision, then you have to accept really the contract as it is, and your only hope for getting out of the contract, if that's what you want to do. Now remember, the reason why you entered in the contract is because you want that house. There are no 2 parcels of real estate that are exactly alike, and some people just want that house. But once you've gone beyond those time periods, you're really out of luck. The only thing that's going to save you is your ability to get a mortgage. If the property doesn't appraise at the amount that you're borrowing, or if your credit's wrong or bad, or there's some other issues of that nature, then you're not going to be able to get financing.
So let me get this straight. If you're a seller, you enter into a contract with a prospective buyer, you agree on the price, the approval period for the attorneys has been long past, they never did an inspection, you think you have a deal, and lo and behold, they tell you they can't get a mortgage? Explain how this works.
That's correct. There is also a mortgage contingency that is in the contract as well. And that generally is set at approximately 30 days or so to allow the purchaser to secure what they call an unconditional mortgage commitment, except as to matters of title and survey. And that means essentially no conditions with respect to the commitment. However, there's a time period, and if the purchaser doesn't serve notice on the seller by that time period that he didn't secure an unconditional written mortgage commitment, then the purchaser waives that provision.
Okay.
And then he's kind of on the deal, kind of stuck on the deal.
This is why in the negotiation stage, before there's actually a contract, an agent or a realtor will advise that they're either pre-approved or this is a cash deal, and these buyers don't need to acquire a mortgage. They have cash money, they can buy it. That just eliminates the mortgage contingency completely. It
really would. If it were a cash deal, you bet it would. And that would make you a more attractive purchaser than this other person, even if, say, your offer was a little bit lower than the other person, because they know that it's a cash deal. And you don't have to go through the contingency period. With respect to a pre-approval is just that. It's not really a mortgage commitment. It's just based upon the initial information that you've submitted to your financial institution. You're eligible for X amount of dollars.
But at least it's a good faith indication.
It is.
That this person is capable of getting the financing to purchase your real estate, correct?
It absolutely is. Let's kind of step back a little bit. We talked. Well, let's talk a little bit more about the attorney's approval and the inspection.
Okay.
Because those are important. Again, we've said that the attorney's approval allows you, within 5 business days, according to your contract, to modify any term except purchase price. The inspection provision, generally within 5 business days as well, allows you to have a professional inspector come out and look at the major components of your house. Now, if you're buying something, you want to make sure that the foundation on your house is not cracked, is not leaking, that the electrical system appears to be good, that there's, the roof is in good condition. You're making a major purchase,
sure.
and you want to get some kind of solace. Sometimes even you may want to do, when the contract provides for that, a termite inspection or pest inspection.
Okay. A radon gas inspection.
You might want to do that too. And
what is the average cost of a home inspection?
The average cost of a home inspection, that can run between $275 to $350 to $400. It just depends. And I've seen all kinds of different inspectors and received all different kinds of inspection reports from my clients, and some of them are really more detailed than others. You really want somebody who's going to go out there and is going to take the time and who's going to look at something. Okay. The last inspection that this particular inspector did lasted for a home, it was a 4-bedroom home, probably about 3.5 hours or so. He really was detailed. But another thing you want to understand too, in most of these inspection agreements, the inspector is only going to be limited to the amount of the inspection. So, and understand, they're kind of general inspectors, but to look at your heating system, that would require somebody else. But you just want to get a general idea that the major components are in good operating order. The inspection provision in the contract generally just allows you to make modification requests just based on those major components. It excludes routine maintenance items. So if he inspects it and says, hey, listen, the furnace is dirty, it should be cleaned and inspected by a licensed HVAC contractor. Okay, well, that's nice, but pursuant to the inspection provision, it's really not an allowable modification because that's a routine kind of maintenance item. However, we talked before that the attorney's approval provision allows you to modify any of the terms except for contract price. So at least in my practice, when I'm representing a purchaser, first thing we do is make sure that we get that contract. We make sure that they have that inspection so that we can send out our modification request on time. So we do it pursuant to the attorney's approval provision and pursuant to the inspection provision, so that anything that's not really kind of goes along with the inspection provision is taken care of by the attorney's approval provision as well.
So basically we have 3 items that could end the deal. The attorney approval.
That's right.
If there's modifications that are requested that are not agreed upon, that can end the deal.
That's correct.
The inspection by the professional. If he or she uncovers something that cannot be either repaired or negotiated, that could kill the deal. And thirdly, a mortgage contingency. If everything else is working out perfect, but the buyer cannot secure financing, the deal's done, correct?
That will, if they give the appropriate notice.
If everything's done within the proper time period.
Right.
Then, and they get their earnest money back, they get everything.
That's right, they would get their earnest money back. It's really...
And seller starts over again. Hangs the sign and starts over.
That's true, and that could take another couple of months.
There goes the summer.
On down the road.
So much for moving when the child was out of school.
Yeah, but you do the best you can with what you have.
Right. Let's talk about if everything goes well. We set a closing date.
Right. Well, I want to just touch on, just really quickly, again, those modification requests.
Sure.
Because you have a contract, okay, between each other, between the buyer and the seller. Now, when the seller, or rather when the buyer, after an inspection, say there's a crack in the foundation and he wants that repaired, or something else that's revealed by the inspection. When you request that the sellers either repair that or give you a credit, and you can do that, you can request that they repair it or give you credit, you're really making a counteroffer now on that contract. And that is what we're talking earlier about, making the contract in jeopardy of being terminated. Because now the seller can say, no, I don't want to do that, and since we don't agree pursuant to the inspection provision and the attorney's review provision, we're declaring the contract null and void and we'll return the earnest money. So every time that you make a modification request, you do take the chance that the contract or the deal can be terminated for that reason.
Okay. So agreeing on the purchase price only started the contract. Any modification further has to be agreed upon by all the parties.
Right.
Otherwise, there's no deal.
Right, because it's a counteroffer. And then if it's a counteroffer, there's really no deal. And again, just for the people out there, whenever we do our letters for modification requests and we do them, we ask that those repairs be conducted or be affected by a licensed, bonded, and insured contractor, whether or not it's an electrician or general contractor or anything like that.
Okay. Well, let's assume everything goes well. We got a nice piece of property. Attorney's happy with the agreement. The client is happy with the agreement. They've secured the financing. They want to set a closing date. How solid is that date? Does it have to happen on that closing date that they set in the original contract?
It's in the contract, and so if you've agreed on a specific date, then that's the date that you're going to be closing. However, common courtesies are extended. There may be a difficulty, even though you do have the financing, the purchaser has financing, the lender might not be able to get the package together in time to close on that particular date. Now, it does happen. It shouldn't, okay, but it does. And generally, the seller doesn't want to go through all the things that we're talking about before and not extending that and not agreeing to kind of to close at a later time.
So it could be moved by agreement?
It can be moved by agreement, but another important thing to remember, too, is a lot of these deals involve sells and buys. So I'm selling my house to you, but I'm also purchasing a house from somebody else. And generally, I'll have that on the same day because in order for me to buy my new property, I'm going to have to get the funds from this property. So we'll schedule my sale to you in the morning and my purchase from this other person in the afternoon. And if there's a problem with the closing date, it has a domino effect, and it affects the other deal too. And then I have to deal, as the seller and the buyer of this other place, I have to deal with those ramifications with the other parties.
Well, time is clearly of the essence because even if you do the closing on the same day, you have to schedule the title company, the moving trucks, everything to get out of the property. What if the seller has not vacated the property that you've already closed on? What do you do? Well,
generally in the agreement, it has a provision with respect to possession. Most of the time, possession is tendered at the closing. That means that, hey, after you sign those documents and the checks are cut and everything else, then you get the keys, the garage door opener, all that stuff, and
everybody's happy.
And everybody's happy. Now, sometime, and you'll know whether or not the person has moved out because you'll get an opportunity to do a final walkthrough with your realtor to make sure that no walls were damaged or the washer and dryer is still there or the same refrigerator that was there when you agreed to everything is still there. You get an opportunity to kind of look through that. So that'll give you a tip. Sometimes, however, the seller needs to remain because he hasn't scheduled his closing kind of back-to-back like that. And make no mistake, to be able to do it back-to-back takes a lot of fine, intricate detail. It takes a concerted effort on many different variables, many different parts to be able to get that together. So sometimes what will happen is that person will want to stay after they sell it for a week or a month or whatever the case may be, and that's called a post-possession. And the real estate contracts generally have a way of dealing with that, and you'll enter, and if they don't, I know that the 3.0 contract does, but there could be a separate agreement, post-possession escrow agreement, that you enter into that would essentially take about 1% of the proceeds of the sale. And that would be held in escrow by the title company or by the purchaser's attorney or by the seller's attorney. And it's subject to an agreement that lists all of the conditions and requirements. For example, it's going to be for 30 days. But if you're not out in 30 days, then the amount of the daily rental is going to go up tremendously.
So basically the seller is paying rent to the new owner.
That's right.
At an agreed-upon rate from the contract.
That's right. And also the reason why 1% goes up, it's not just to secure the amount of the rent, but also it's to secure any monies for damages that might occur when the seller moves out, because now the seller doesn't own it anymore because he sold it. So if he is moving a bed or something and scrapes the wall or crashes through the wall, that's going to have to be repaired, and that's going to have to come from the reserve that's taken care of by the escrow.
Let's talk about another part of the contract that we kind of overlooked, and that's the residential real estate disclosure statement, whereby the sellers, the people who have lived in the property, disclose in writing under oath, whatever, that there are no material defects to several different items in the house, from foundation to sewer to electrical. Is that correct?
That's correct. To roof, to flooding, to the well and septic system.
Yeah. Now, sometimes these forms just get waved in front of a seller's face by a broker, and there's not a whole lot of thought put into it. But we both know, because we've been involved in litigation on this issue,
that's right,
that a seller has to be very, very careful filling out that form, that they're telling 100% truthful statements.
That's
For example, a cracked foundation, a leak, faulty wiring. If they know about this, what can happen?
Well, if I'm aware of those conditions and I don't disclose that on the disclosure form, then that could be ramifications for me later on down the line, because after I sell the property and the purchasers, now the new owners, take possession, the rainfall comes, and now they have water in their basement. And if I knew about it and didn't disclose it, now they can sue me and collect their actual damages and potentially attorney's fees.
Okay, so it's always best to disclose any defect and either negotiate it in the purchase price or remedy the problem before you sell it, correct?
That's correct, too. There is, to the Property Disclosure Act, there is kind of a defense, and that is if the person who made the statement, if the seller reasonably believes that they've corrected the problem, that they don't have to disclose it. But the better course of conduct really is to disclose it anyway, even if and it gives you an explanation, a place to mark down some specifics about what that is. Even though you might have a defense, you don't want to hang that defense. You don't want to go to litigation.
Right.
You don't want to pay an attorney to thousands and thousands of dollars to defend against somebody's claim.
Sure.
That's really the best course of action.
If the buyer accepts that property in that condition, knowing about the condition, you're okay as a seller.
You're fine. There's also a lead-based paint disclosure, too.
Okay. Let's talk about that. Lead-based paint, what is it?
Yeah, lead-based paint is, lead is obviously no good. It's a health risk. And sometimes if you have children, they can eat paint chips, and that can cause severe health problems for them. And so
they ingest it without
exactly, because they're kids. They don't know. They put things in their mouth. And so I believe it's anything built actually after 78 doesn't have lead paint, but anything before that can. And essentially what the disclosure does is it allows, again, it's disclosure. The seller's saying, I'm either aware of lead paint or I'm not aware of it. I don't know.
Okay.
And it gives an opportunity for the purchaser to have an inspection if they want. And then generally you get a pamphlet talking about lead-based paint in your home, a little bit more specifics on that.
Real estate taxes is another issue that's always involved in a sale or purchase of a home. What's the deal with that?
Well, and there is a, in the contract, it's, in the 3.0 contract, it's number 9, it's prorations.
Tax prorations.
Tax prorations. And essentially what happens is that we all pay real estate taxes in arrears. That means, just like when we pay, our income taxes, okay? Sometimes you send an estimate and you're paying it for the year before.
Right.
For real estate taxes, it's the same. You're paying in arrears. So this year I'm paying for last year's. And so when you sell the home, you really owe the taxes for this period of time, and the purchaser isn't going to get stuck with that. So what happens is that the purchaser receives a credit for what's going to become due.
Okay. So the bill that they haven't received yet, they're getting a credit for.
Right. And sometimes, and because it's paid in arrears and you don't know exactly what it's going to be, it's based upon the last ascertainable tax bill. Now, if the tax bill is paid, then that's fine. It's that actual. But there's going to be a prorated amount through and including the day of closing. And it's either prorated, it could be prorated at 100%, it could be prorated at 105 or 110. And the reason why it's prorated at a higher amount is so that in case taxes go up. If taxes go up, then that extra 5%.
Wait. If they go up?
Well, when they go up.
Have you ever known them to go down?
Well, I haven't really known them to go down, but sometimes they stay the same.
Okay. So I know in Cook County they don't go down.
Well, the difference is 5 or 10%. Generally, we see most of the time it's at 105%. If you're the seller, you want them to be 100% prorated. If you're the buyer, you want them 110%. That's also another area in terms of negotiation or in terms of attorney review, the attorney review provision, that you can make that kind of a modification.
And depending on the value of the property, that could make a significant difference, that proration, correct?
It could. For the most part, on a $275,000, $300,000 home, you're probably looking at a difference of a few $100s in terms of that 5%.
Okay. When you purchase the property, you want to make sure there's no liens against the property other than a mortgage lien, correct?
That's right, and that's taken care of with respect to the title insurance. The seller is required to obtain a title insurance policy, and there are several different companies out there. We won't mention them, but there are several, and the title cost for the title policy is split. The purchaser pays a portion and the seller pays a portion. There are various what they call endorsements. Essentially, what what they're guaranteeing is the chain of title in terms of who owns it, and they search the records to see the transactions in the past. Sometimes lenders require a 24-month chain of title, so you go back 2 years to see where the property has passed. And that's to guarantee that, hey, listen, if anybody comes and makes a claim against the property that you purchased, the title insurance is going to be there to defend and protect against that.
Okay. Who prepares the documents for the closing? Is it done by the attorney? Is it done by the title company?
Well, for the seller, the seller's attorney has documents to prepare. They have to order the title, they have to prepare the bill of sale, they have to prepare affidavit of title and an ALTA statement. Essentially, ALTA statement is saying that the seller has the interest that he's conveying, and that for the past 4 or 6 months he has not encumbered the property, has not had any services that anybody can lien the property.
Like a judgment lien that they might owe money, and then they got sued, and there's a judgment recorded against their property.
That's exactly right. And then also the seller's attorney has to prepare the tax documents. There are county taxes, there are state taxes, and sometimes municipal taxes for the municipality. Sometimes for the local municipality, it's a seller's charge, and sometimes it's a buyer's charge. So, and generally it can go from anywhere from $1 or $1.75 per thousand in terms of purchase price.
What's an average attorney fee for a closing if you are selling a property?
Attorney's fees range. There's a huge range. It can be anywhere from $250 to $550, just depending. And some people do more volume. They just do real estate, and so they're in a better position to be able to offer a lower fee. But what you really want is somebody that you're going to be comfortable with. Okay, somebody who's done real estate in the past,
right,
and someone that you have a good relationship. Someone who's going to pay attention to these deadlines.
Yeah, definitely hire someone who does real estate, not somebody who does other areas of the law and an occasional closing, because you're gonna run into problems typically.
You want somebody who does that on a regular basis. That's right.
Well, thanks, Jesse, for joining us.
You're welcome.
Very informative. We learned a lot about real estate. Now is the time. Buy, sell, get it done. Thanks for joining us. See you next time. Bye-bye.